joining today's session, where we'll be talking about the variable consequences of a civil marriage and concentrating on out of community of property. Before I start, please let's remain muted and only unmute if you have a question or if you want to say something. Last week we were discussing community of property, where I stated that, or where we learned that the community of property occurs by default. That is when the parties do not enter into a contract, an antenuptial contract, whereby they say they do not want to be in community of property. Now, out of community of property arises when the parties or the engaged parties, they need to enter into a contract called antenuptial contract. The purpose of the antenuptial contract is to deviate from some of the common law or statutory rules regarding the matrimonial property consequences of a marriage. An antenuptial contract, it is a written document that has to be entered into before the parties enter into a marriage, and preferably it has to be drafted and signed and registered at the deeds office within 3 months before the parties enter into a marriage. But it has happened many times, or numerous times, that the parties enter into an antenuptial contract just after the 3 months prescribed period, but before they enter into a marriage. The most important aspect of an antenuptial contract is that it must be registered at the deeds office before the parties have a marriage certificate, or they sign the marriage certificate. If the parties sign a marriage certificate having had the antenuptial contract drafted, but it is not registered before, or it is registered after they have signed the marriage certificate, their marriage will be automatically in community of property. So it is important to know that even in practice, that with an antenuptial contract, the parties or the engaged lovers, they must ensure that the contract it is signed and registered at the deeds office before they sign the marriage certificate. And an antenuptial contract has to be notarized by a notary. As you know that as prospective attorneys, you can decide that you'll just be an attorney, or you'll be you'll be an attorney or an advocate. But if you want to draft antenuptial contract and notarize them, you have to be a notary. Conveyancers who specialize in property law cannot notarize antenuptial contract. Ordinary attorneys who are not notaries cannot notarize antenuptial contract. Preferably, it must be drafted and signed, notarized by a notary. And an informal antenuptial contract is when the parties have drafted the antenuptial contract, but they do not take it to the deeds office. That antenuptial contract is only binding between the parties. It is not binding on that parties. That means that, let's say, for example, Mr. A and Mrs. A, they've got an informal antenuptial contract whereby they say to themselves, we are not going to be responsible for each other's deaths. Your assets are going to be your assets. My assets are going to be my assets. But when it comes to that parties are going to view their marriage relationship as in community of property. So that antenuptial contract, because it is not registered at the deeds office, it is not going to be binding on any other person other than the married spouses. In the case of Matabate versus Matabate, it was stated that an antenuptial contract is an intended promise of marriage or contract of betrothal or engagement to be married. please, student, it is important that you note in your textbook, you note the relevant cases, and you note the important information or what was said in court, because in your exam, which is going to be an MCQ, multiple choice questions, you can get a question whereby you just get a statement and then you are being asked, okay, in which case was this said? Or you can get a question just says, okay, what did the judgment in Matabate versus Matabate said? So as you are studying, please make sure that you note the important judgment and what the court has said. Before I continue to talk about the types of antenuptial contact, does anybody have any question? Does anybody want to say anything? Can I take it that we all understand? Okay, now we are going to talk about the types of antenuptial contact. We've got 3 types. The first one is marriage out of community of property, and marriage out of community of property without the accrual system. That is also called a complete separation of property. Here, the spouses do not share anything. Whatever each spouse had before they entered into a marriage, whether assets or debts, they retain them. The only assets that the parties will share are the ones which they jointly own. And as you are aware that how most things are done in our country, there are certain items that when you buy, only one person can be registered, and then there are others where both spouses can be registered. The most common examples are a motor vehicle and an immovable property. A motor vehicle, even if the married spouses can decide that you are married out of community of property, but you are both going to financially contribute towards buying this motor vehicle for our family. That motor vehicle is only going to be registered in the name of one spouse. And if it's registered in the name of one spouse, it will belong to that spouse estate. But when it comes to an immovable property, the law allows that both parties can be registered in the title deed of the immovable property. And then when spouses are married out of community of property without the accrual system and they jointly own an immovable property, this is an item that 50% will belong to the estate of the wife and the other 50% will belong to the estate of the husband. As I said, they are not liable for each other's debts, and each spouse is free to do whatever they want to do while being married. Remember, when you are married in community of property, there are certain transactions that you cannot enter into without the written consent of your spouse or the verbal consent of your spouse. But if you are married out of community of property without the accrual system, you are free to do whatever you want with your estate. You are not accountable to your spouse. Spouses who are married out of community of property without the accrual system, they can also sue each other. Remember, when you are married in community of property, spouses cannot sue each other. But when you are married out of community of property, the spouses can sue each other. Okay, this is just a summary of out of community of property without the accrual system. Before I move on to the next type of antenuptial contact, does anybody have any question on the complete separation of property? I take it that everybody understands. Okay, no hands is good news. The second type of the antenuptial of the out of community of property is out of community of property with the retention of community of profit and loss. Now, how this is different from income of property. This entails that the prospective spouses, they enter into an antenuptial contract where they agree that all the assets and all the debts that they have before getting married, they're going to be retained by the individual spouse. But everything that is accumulated after they have entered into a marriage is going to be shared equally. So, for example, when you're married in community of property, if your spouse has a student debt, you automatically become liable for that debt. But if you are married out of community of property with the retention of community of profit or and loss, that student debt you are not going to be liable for. But if your spouse makes a debt while the two of you are married, the other spouse is going to be liable for that, because in terms of their marriage contract, everything that they accumulate and all the debts that they made while married, they are going to share them as if they are in a joint estate marriage. Does anybody understand? Anybody has a question? Okay, thank you. These two examples are fairly easy because they are straightforward. Now we are going to discuss the last option. We are going to discuss the last type, which is marriage out of community of property with the accrual system. So how it happens is when prospective spouses enter into an antenuptial contract, if they don't want their marriage to be with the accrual system, in the antenuptial contract, they automatically they need to state that we do not want the accrual system to be applicable to our marriage. If the antenuptial contract does not have that clause, their marriage is going to be subject to the accrual system. So this means that the accrual system is the default system when you enter into an out of community of property. Just like when you don't sign the marriage certificate, the default system is community of property. Without out of community of property, the accrual system is the default system. Accrual means it is the amount by which the net value of the spouse's estate at the dissolution of the marriage exceeds the net value at the commencement of the marriage. Let me try and explain to you using practical examples. Mr. A and Mr. B, they enter into a marriage subject to the accrual system. They enter into an antenuptial contract. In the antenuptial contract, there's going to be the first section. It is what it is written, commencement value. So in the commencement value, they need to state all the assets that they have and all the debts that they have. If they don't have any assets, or if they have more debts, or if their debts are worth more than their assets, the value of both their estates are going to be regarded as nil. So each and every antenuptial contract, it has an antenuptial contract that is subject to the accrual system. It has a commencement value. Then they sign the antenuptial contract, which have all other clauses that we will discuss about them later. And then during the marriage, depending on the terms and conditions of their antenuptial contract, they have separate estates and they are free to do or to administer their estates the way they want to. The accrual is going to apply upon the dissolution of the marriage. So when the marriage comes to an end, whether through divorce or whether through death, there is going to be an accrual calculation whereby both spouses' estate are going to be calculated in order to determine who between the two spouses has a larger estate. The larger estate in terms of monetary value. The spouse whose estate is larger shares half the difference with the other spouse. Let's say, for example, the husband, after doing the accrual calculation, the husband's estate is worth 3 million and the wife's estate is worth 1 million. The wife is going to retain her estate because her estate is lower, and the husband's is the one who has to share the half the difference. So how you share the half the difference? We need to what is it? The 3 million. It needs to be calculated taking into account the CPI, the current CPI value. We are going to discuss about it, how you calculate the CPI. But let's assume that the 3 million is already a net value and the 1 million of the wife is the net value. So we are going to calculate by saying 3 million minus 1 million. The balance is going to be 2 million, and 2 million divided into 2 is going to be 1 million, 1 million. So the husband will have to give the wife 1 million rand from his 3 million rand estate value. That is what we say half the difference. So the term half the difference means that you look at the net value of the spouse whose estate is higher minus minus the value of the other spouse, and then the balance you divide into 2. Once you divide into 2, the balance is what is going to be given to the other spouse. And with the accrual, it is important to note that spouses are not entitled to assets. For example, if let's say the husband has 4 houses, 5 houses, the other spouse cannot say, I want 1 house or I want a share of the pension. With accrual, spouses have a share in terms of monetary value. But if the parties enter into a settlement agreement and they decide that instead of me giving you a monetary value, giving you money, I am going to give you this asset, that is allowed, but it's only allowed through the process of divorce. If death occurs, only the monetary value needs to be shared with the spouse whose estate is lower. Okay, before I continue and I go back to my notes, does anybody have any question? Okay, I'm going to continue. I'm gonna go back to my notes. As I said, accrual claim means half the difference between the accrual of the respective estates of the spouses. A spouse has a right to accrual sharing, and this right exists during the marriage. A claim for accrual only arises upon dissolution of the marriage. This basically means that when spouses are married during the marriage, although each of them are allowed to administer their respective estate without the consent or without getting the consent from the other spouse. Each spouse have a right of an accrual claim, have a right of the accrual sharing, but the right to claim from the accrual only arises upon dissolution of a marriage. So it's a right that you have, but it is not enforceable until the marriage comes to an end. In the case of Reda versus Softline, it was held that pending the dissolution of the marriage or an order in terms of Section 8 of the Matrimonial Property Act, one spouse merely has a contingent right to the accrual in the other spouse's estate. Then I said note Section 8 of the Matrimonial Act deals with the powers that the court has when dividing with division of the accrual. Okay, students, does anybody have any question? We all understand? Okay, now we are moving to the most important aspect of today's session, and this is how to calculate an accrual. Calculating an accrual, the first thing is you need to determine the net commencement value of each estate. And this net commencement value, you find it in the antenuptial contract, the document itself, because no antenuptial contract can be registered at the deeds office if it does not contain the clauses that deals with the commencement value. So if, as I said, if the spouses did not have anything, the net commencement value is going to be regarded as nil. So in the antenuptial contract, they are going to write nil on both spouses. Once you have determined, or when you have seen that, okay, this is what the commencement value was, the second is to determine the gross end value of each estate. How you do that is, okay, you take, let's assume that each spouse, their net commencement value, let's say it was 1 million for both parties, and then the conditions, the terms and conditions in the antenuptial contract, they say donation, inheritance is not part. It should not be included when calculating the accrual. And then let's say one of the spouses say had the house, or had the house, in other words, the 1 million was the monetary value, and then there was an immovable asset, and then they stated in the antenuptial contract that when calculating the accrual, this immovable property should not form part, when you calculate the accrual. So all of those, they need to be deducted up until you reach the gross end value of each, not the gross end value. The gross end value is you calculate everything that each spouse has. Then after you calculate everything, you start removing what is not supposed to form part of calculating the accrual. Once you have removed everything, you're gonna end up with the net end value. The net end value of each estate. Then once you have the net end value, you deduct the net commencement value, and deduct the net commencement value and deduct assets that do not form part. This so that you determine what is the net end value. Okay, student, before I continue, do you understand, or does anybody want me to repeat it again? The steps that needs to be taken in order to determine the net end value. Can I get thumbs up that says you understand? Okay, Lebran says please repeat. Okay. So as I said, the document itself, the antenuptial contract, it must have the net commencement value. And let me just point out that upon the divorce, upon the dissolution of the marriage, whether through death or through divorce, the net commencement value has to be adapted to the current value at the present moment that we are. For example, if the parties got married in the year 2010 and they are divorcing in the year 2021, when you determine the net commencement value, although you're going to look at how much it was, as it is stated in the antenuptial contract, there is a calculation that needs to be done so that you adapt that amount to reflect the value as the year 2021. So we are using the amount of 2010 when they got married, but the value we are going to adapt it so that it reflects the year of 2021. Let me give an example using a house. We all know that houses they grow in value. Yeah? You can buy a house in the year 2010 at the cost of, let's say, 500,000, and then in the year 2021, that house is now worth 750,000. So meaning that it has grown by 250,000. So with the net commencement value, it's something like that. Wherever you say, okay, the net commencement value at the time of marriage, it was 500,000 rand, but now as we are calculating it, instead of us saying, okay, the net commencement value is 500,000, we are going to say it is 750,000 rand, because we have adapted it to what is the current value in 2021. So the first thing is you determine the net commencement value. Then after determining the net commencement value, you determine the gross end value of each spouse's estate. So each spouse, let's say they have to list everything that they have, from theirs, from asset, everything that they have. And then after listing everything that they have, you start, which is, you go to number 3 now, you start deducting what is not supposed to form part of the accrual calculation. So once everything, like your debts are not supposed to form party, inheritances are not supposed to form, donations is not supposed to form part, and the net commencement value is also deducted from that. Once everything has been deducted, you are going to end up with the net value of each spouses. So that is how, because calculate the accrual, we calculated using it the net end value. Yes, that is how it is. Student, those who want, I can give you, you can send me an email, then I can give you a summary of my notes as I've drafted it there. And then if you are still having challenges understanding this, what we can do, we can also set up a one-on-one session or an email communication whereby I clarify some of the challenges that you have. Yeah. Okay, but here where I'm pointing, these are calculating accrual. I said to you, student, that the net commencement value, it needs to be adapted to the time, the present moment that the parties are divorcing, or the marriage is terminating, whether through a divorce or through death. So the net commencement value. So now I want us, I've shifted my nose. I want us to talk about how we calculate the value so that we adapt it to the current, to the present moment where we are. So we say the commencement value, as it is stated in the ANC's antenuptial contract, we say the commencement value in the ANC is multiplied by the average CPI as at date of the dissolution of the divorce, and then thereafter it is divided by the average CPI as at the date of the commencement. Okay, we'll look at the example. I just want to make you aware that should you get a question like this, the question will give you an example of an example of this is what the CPI value as this year or at that year it was. You will never get a question from us about CPI without us giving you what the CPI was during that year. Okay, an example. Mr. and Mrs. Joe Doe were married in September 2010 and they divorced in February 2021. In September 2010, John Doe had a commencement value which was 10,000 rand. According to the CPI table, in 2010, the CPI was 0.26. This was the value in the year 2000. And then during the year when they are divorcing in February 21, the CPI is now 120. So we say we take this 120, like the CPI value at the time of the dissolution of the marriage, we divide it from at the time when the parties entered into a marriage. So the CPI value at the date of the dissolution of the marriage is divided by the CPI value at the time of the date of the marriage. And then this is going to be the result. Then we take the 10,000 rand that is reflected in the antenuptial contract. We say this amount times we multiply it by the CPI value now as we calculated it, and the result will be 46,153. This is now the adapted commencement value. Instead of saying the commencement value was 10,000 rand, we are going to say the commencement value is 46,153. Students, I cannot see because I was looking at my notes. I see there's a hand up. Just hold on, let me check. Okay, just hold on. Molebogeng, can you just hold on a bit? I just want to do something. I see your hands, ne? Molebogeng, just hold on. Okay, Molebogeng, you can ask a question.
Okay, there's a question in the chat.
Okay.
By Believe, he says, does the accrual apply only to the monetary value of the spouses to the exclusion of other fixed assets?
Okay, the fixed assets, they also form part, but their monetary value. Remember, each and everything has a value. An immovable property has a value. Cell phones has values. So when we talk about the value of your estate, we say, let's say you get a valuator and comes and values everything that you have from fixed properties, from your motor vehicles, from your laptops, from everything, every asset that you have that does not form part of the accrual. Okay, before I talk about that, let me say everything that you have is going to be valued so that it is known what value does a spouse have in their respective estate. So if the husband, after valuing everything, including companies, and then it is determined that his estate is worth 10 million, and the wife's estate is worth 5 million. This is the gross value of their estate. And then from there, you start deducting what is not supposed to form part of the accrual. So you deduct the commencement value, which is sort of mean 10,000 is now 46,000. You start deducting donations, any non-patrimonial damages which were received, anything that which is not supposed to form part of the accrual calculation as per the antenuptial contract. Then you deduct it. Once everything has been deducted, what is left is the monetary value. So that monetary value, it can be on paper. The spouse might be in a position whereby they do not have the cash. Let's say it's the wife who does not have any cash but has two immovable properties which now forms part of her net estate, and they are valued at 2 million rands. Understand? So when we talk about your estate, we are talking about your assets and everything. It happens most of the time that those values, they are taken on what their immovable assets are or what their movable assets are, but not necessarily that what is it? They actually have the cash. This also includes the pension fund, the provident fund, the retirement fund. If the antenuptial contract is not specific by stating that the pension interest are your provident fund, pension funds, and retirement annuities. If spouses are not specific that they should also not form part of being included when calculating the accrual, that again the value at the time as you get your statement from the pension administrators, it is included in calculating how much is your estate worth as a spouse. So that's what we talk about when we talk about the monetary value of each spouse. Okay, Mlebogeng, I trust that I was able to answer the student. Unless if you have another question, Mlebogeng, please remove your hand.
I have another question.
Okay.
The student asked, why do we divide the CPIs?
That is just how it works. That is the calculation that is used to determine the CPI. I'm going to be very honest. I myself, I can't say I know why they're using this formula, but it is a formula that is being used and it is prescribed for everybody. So it is one of those things, the laws, the principles that we found them in South Africa, and unless if maybe somebody does a research to find out the background of this. But it's a formula that it is used not only by the attorneys but by who are those that profession that specialize in finances and all of that. The accountants, they also use the same formula. Okay, thank you. Before we continue, does anybody understand belief? Belief, you can ask a question. Belief, unmute yourself.
Hello, ma'am.
Okay, hi, Belief. You can ask, Belief.
Okay, I've got an imaginary question that I have here. It's just an imaginary situation that I had in my head. Let's say, for example, the couple are divorcing, and the other wife, be the husband or the wife, does have an accrual that is larger than the other spouse. If I start selling my assets at that particular moment when someone had already instituted divorce proceedings, like I'll be selling them with the objective of prejudicing the other spouse to make sure that she or he doesn't get anything from my assets, to make sure that maybe by the point the divorce order will be given, our assets will be at equal terms in terms of value, our estates. Is there any mechanism in terms of the law to protect that? Like, for example, if I'm trying to prejudice my wife by selling or changing ownership of the houses or some of the properties so that my estate will be of the same value with theirs?
Yes, the other spouse can get an interdict to stop you from prejudicing. So we actually have that information in the textbook under the heading "Protection of a Spouse Right to a Share in the Accrual." The prejudiced spouse may apply to the High Court either for an immediate division of the accrual, or they can apply to interdict you, the other spouse, so that you do not dispose of the asset. If some of the assets have already been disposed of, their values will be used to calculate how much it is. Remember, I said spouses are not entitled to the assets. They are entitled to the monetary value. So you can get rid of your assets, but as long as the other spouse, the prejudiced spouse, they are able to prove that you intentionally sold or disposed of your assets in order to prejudice them when it comes to accrual calculation, and they succeed in their application, they are going to use the value of the asset that you have disposed of to actually calculate how much your estate is actually even though you have already disposed of those assets. And then let me say, maybe you've already disposed even of the benefits, the monies that you received as a result of that disposal. So thank you for that question. It was a good question. What I want to say is, what happens while spouses are still married, this is something that I know it happened in real life, because somebody was just sharing it with me, whereby this couple was married out of community of property with the accrual system. So what happened is the husband was not building his estate. Instead, he would buy expensive cars, and then each time when he had money, he will, lump sum of monies, he will transfer it to his brother's account and all of that. He always made sure that as the parties are married, he does not grow his estate at all. While on the other hand, the wife had bought a house in an estate, and they were both living there. Because remember, it does not matter who is the registered owner of the immovable property. One of the invariable consequences of a marriage is that you cannot evict the other spouse from your house. So the lady was busy building her estate, and the immovable property was registered in her name. And I think 12 years later, the marriage failed. And when the parties did the accrual calculation, the husband received 50% of everything from the spouse, because when you look at half the difference, if the spouse estate is sitting on nil, but the other spouse's estate, it has some value. So let's say it is 1 million. So if you say 1 million minus 0, the results will be 1 million. And then you divide that 1 million into 2. The other spouse receives 50%. So some spouses, what they do is they don't wait for termination of the marriage. While still being married, they make sure that they do not grow their estate at all, or if they grow them, they either find a way to hide their monies or create a trust, because a trust, again, a trust does not form part or if a trust is a separate legal entity whereby everything that you have belongs into the trust. So you'll find maybe a spouse who is married out of community of property with the accrual, and then is a business person, and then will accumulate everything in the name of their business, and then put all those assets in in a trust. While their spouse, let's say their spouse is not a business person, they have their income, they've got their pension fund from work, and then they are busy building or having assets in their own names. This will automatically mean that upon the dissolution of the marriage, that spouse who have assets and monies under his or her name, and some of those assets are not excluded from forming part of the accrual calculation, those assets will automatically form part of their estate, whereas their spouse will forever be sitting on 0, because they would make sure that whatever I do, I will have to make sure, as in my individual capacity, I do not have anything. So this is one of the disadvantages of accrual system, whereby you are married to a spouse who is not fair, and then who ensures that whatever they do, they are not going to grow their estate, so that upon the dissolution of the marriage, there is nothing to claim from them, or if they have something, their estate is such in a very, very low value that they get to retain. Because remember, I said the spouse whose estate is lower retains everything that is theirs, and then only a spouse whose estate is high in monetary value has to share half the difference with the other spouse. So although it happens that upon the divorce, others try to defraud the other spouse, most of the time it happens while the parties are married, and during that time it really becomes extremely difficult. It becomes extremely difficult to actually manage. And if you want to take the matter to court, you cannot take the matter to court for the court to force your spouse to work and build their estate. If they're business people and they say everything that they do it in the name of their business, because it is the business itself which is accumulating those assets, there is nothing really that the court can do about that. Understand that? So unfortunately, although the accrual system it's a compromise between all these other marriage contracts, including the in community of property, it can actually work against a spouse who I don't want to say an innocent spouse, but who was fair, and then who was building in the marriage, thinking, he's working for the family, he's building, only to find out that they are just building for the other spouse to benefit. Okay, Mukibela, please unmute yourself. Morning, Mukibela.
Good morning to you. Good morning, everyone. I just wanted to make a follow-up on, I believe, a case that he has stated there. But I want to put a scenario here so that I understand it quite clear. Where do we go from here? In this scenario, one of the two couples, anyway, they were married in community of property, and they were both working. And when they were working, marriage has got more stages where it goes that sometimes you may find that they are no longer in love properly, but someone realizes there's going to be a pending divorce that might take place. And this incident, the spouse went to go and resign from her work. After resigning from her work, then she spent all the benefit that she got from her pension fund.
Mm-hmm.
Thereafter, there was this case of now starting to prepare for a divorce. And she went in, because they were married into community of property, she went into the employers of her husband to ask for a 50% of the estate, for which she got the money because she didn't have anything, and she didn't have to share anything from her. And later on, when the whole process of dissolution of the whole thing was done, the husband realized that she didn't have any money, whereas she got the money and she saved it somewhere. After the divorce, then she bought a property. What can the husband do in terms of this scenario of this case? Thank you. Thank you, Kathleen.
The husband can do an amendment rescission of the divorce part to must do a rescission of the divorce, and in the application he must actually state, he must plead, and in court he must prove that the wife intentionally lied and defrauded their joint estate, and at the time during the process of divorce he was misled. He was made to believe that the husband, not the husband, the wife. Okay, let me just ask something. Did you say during the process of divorce, the husband became aware that the wife does not have 50%, or it's only after the divorce. In other words, the divorce decree said division of the joint estate.
Yes, I said that, Kathleen.
Okay, yes. Then that's a rescission of judgment, meaning that the wife misled the husband and the husband's legal practitioners by giving the impression that she is still employed and the husband is going to get 50% from the pension fund. This application is really not easy to win unless the husband can prove that the wife intentionally misled the court and misled misled the spouse and the legal practitioners by giving them false impression that the husband is going to get 50% of the pension fund. What you need to know is for the pension fund to be given to the non-member spouse, the divorce decree or the settlement agreement need to specifically state that the court orders 50% to be the court orders, it says, I just forgot the specific wording of it, but it's a specific wording that needs to be in the settlement agreement or to be in the divorce decree. So most of the time, the legal practitioners do not issue or do not grant a termination of the marriage if that clause is not there. So if the wife gave the husband that information and it was included as a court order, while she knows that she has already resigned and withdrew the monies from the pension fund. So the husband can do a rescission of judgment. Alternatively, what the husband can do is the husband can bring an interdict application to have the wife bank account and all her financial account frozen, so that whatever 50% value that the husband was supposed to receive can be taken from all her account. Or alternatively, the husband can get a court order that the immovable property be sold and the husband be given the 50%. The word division of the joint estate protects the husband because automatically it means the wife has to give the husband 50%. In other words, they both have to share each other's 50%. So that word gives the husband various options. But and then you also we have to be aware that a court order, including divorce decrees, they last for 30 years. So the husband, if they can find how much value was when the wife resigned, and that will ensure that they know how much they are entitled to, and then they can sue either the wife or do a rescission of a court of the divorce order. And in the rescission, maybe they can request that because the wife has withdrawn her pension monies, she be stopped from getting 50%. So they request for rescission of judgment so that that order that says each parties they have to share each other's pension funds. It reflects that every party must retain their pension funds. So those are the various options that the husband have. Do you understand?
No, I do understand now. No, I've been clear. Thank you very much, Kathleen. Thank you so much. Thank you.
Yeah. Students, does anybody have any question on calculating the CPI? As I said, student, you can send me an email, then I can email you this note that I have done, where I tried to actually summarize how the accrual system works. Yeah? And what other information that we need to know? The other information that is very important, student, which is not in your textbook, né? The date on which the value of the spouse's estate is to be calculated for the purpose of accrual sharing. If the marriage is dissolved by death, the accrual of the deceased spouse's estate is determined before effect is given to any inheritances or donations. Basically, this means that before there can be any inheritance can be distributed, there firstly must be accrual calculation, and whichever estate is higher has to share half the difference. And I'm saying this thing because if there is death, one spouse has passed away and their estate is lower, the surviving spouse needs to share half the difference to the deceased estate. And then it happens sometimes that the deceased estate had left a will whereby they disinherited the surviving spouse. So the surviving spouse will share half the difference with the deceased estate, and their share is going to be distributed to whoever is nominated in the will. If the surviving spouse name is not there, unfortunately, they're not going to get anything from the deceased estate. So in other words, I can say they got married and then their estate they shared with the deceased, but at the end of the day, they did not benefit anything in terms of monetary value. The only thing they benefited from this marriage was love and intimacy and nothing else. And if the deceased estate is the one which is higher than the one of the surviving spouse, then the deceased estate firstly needs to pay the surviving spouse their accrual share before they can do distribution. So if, let's say, the surviving spouse is also entitled to inherit. Let's say they are nominated in a will or there was no will. So the surviving spouse will firstly get the accrual claim and thereafter also get a share when they distribute inheritance. Then, if a marriage is dissolved by divorce, you will note in your textbook that it said that the answer was really not clear, and then there were numerous judgments where in other judgment they will give this date, and then in another judgment they will give another date. This matter has now been resolved by the Supreme Court of Appeal in the case of Brookstein versus Brookstein, also reported as AB versus JB. Here, the court ruled that the accrual at the time of divorce, it is determined on the date on which the marriage is dissolved. The date on the marriage is dissolved is the date the court terminates the marriage, and it is not the date the parties separate. Remember, it happens sometimes that before the divorce, parties can go their separate ways, and while still married, live as single people. So when you calculate the accrual, you don't use the value from the date they separated. You use it from the date in which the marriage is dissolved by a court of law. Do you understand? So this is very important that you must know this case, because the position was not clear up until the Supreme Court of Appeal gave us a way forward. Students, does anybody have any question or comment to make?
Ma'am, I have a comment or a question.
Okay.
I'd like to know, I actually didn't even know this meeting was on. I just saw in my WhatsApp group. Are you going to be able to send this recording?
Okay, what happens is the recording, we've got a YouTube channel. I upload them on the YouTube channel, and also they are uploaded on the My Moodle's site. So if you go on the My Moodle site under the announcement, you'll see all the other recordings. This one will also be uploaded there. So I upload them latest on, let's say by Saturday, it will definitely be uploaded, but I try to upload it as soon as it is available.
Okay, no problem. Thank you. And regarding the notes, will they also be uploaded on my
No.
Moodle?
No, the notes I said send me what is it? Send me an email. I'm gonna write my email address now.
Oh,
So
okay.
send me an email, then I will send you a note. When you require the note, just write the accrual notes. Then just say, can you please forward me the notes? Then I will just forward you the notes.
Okay, thank you.
Okay. Does anybody else have any question or anything to ask? I see a hand. Ngubeni. Ngubeni, you can unmute yourself and ask.
Okay, thank you, ma'am. I'm sorry if I had left the meeting just a bit, if you have already addressed this, but I'm struggling to get assignment 2 on the Moodle. If you can please assist me with that, ma'am.
Okay, can you send me an email? I've just written my email address there. Then what I will do, I will just copy the link for the assignment and I will send it to you.
Noted. Thank you, ma'am.
Okay, thank you. Students, thank you for joining today's session. Thank you so much. If you have any questions, please feel free to send me an email or to send Mulebogeng Seerane an email. Mulebogeng, can you please write your email address on the chat so that students are able to communicate with us? Please check the My Moodle site. That is where we make the announcement for when the next session is going to be, and check the My Moodle site again for all the recordings of the sessions that we have had. Thank you so much for joining today's session, and we shall see each other on the next session. Have a good day ahead. Bye-bye.
Thank you. Bye.